think we'll get started now. Thank you all very much for coming. Today we are going to be talking about possession proceedings and giving some of our top tips for practitioners dealing with possession claims. So my name's Amber, I'm a barrister at Radcliffe Chambers, and today I'm joined by Farah, who is a legal director in the real estate disputes team at Shakespeare Martineau. And she's very kindly offered to offer some of her insights and share them with all of you today. Well, the idea behind this talk actually came out of a possession claim I did back in the summer, where my clients were the personal representatives under the will of their father, who had passed away, and his mortgage provider was trying to repossess the house that they were set to inherit. And the practitioners who were dealing with the administration of the estate ended up having to deal with this possession proceeding issue as well. And it wasn't something that they kind of dealt with on a day-to-day basis. So I thought that it would be helpful perhaps for practitioners who don't deal with possession claims on a day-to-day basis, but might see it come up in perhaps a probate context or an insolvency context, to get a bit of a grounding in the most common kinds of possession proceedings. We aren't going to be able to cover everything today. It's such a varied field. That's one of the things that we've been talking about actually. But to kick us off, Farah, what sorts of trends are you seeing in possession proceedings at the moment?
So I think post-pandemic, we saw a real rise in landlords wanting to take back possession for, say, failure to pay rent or breach of covenant, just where there was a moratorium, moratoriums had been lifted, and there was a real rush to try and take back possession. I think things have balanced out a bit now. So landlords are able to consider possession as one of their options. And look at the picture in the round. It might be that tenants have got back on their feet, but they haven't been able to keep up with repayment plans, or the landlord just might want to redevelop and they've considered their property portfolio and they want to now manage their property portfolio, maybe sell some of their assets or repurpose some of their assets. So I think it's balanced out a bit, but I think taking back possession is a really useful tool for a landlord.
Thank you. So one of the first types of claims that we're going to look at in detail is forfeiture. So Farah, how would a typical forfeiture case start for you?
So I think, funnily enough, with this one, as we were discussing previously, I don't think that I've had that many clients come to me with forfeiture at the forefront of their mind. I think commercial property is slightly different to the private rented sector, where landlords really know what they're going for. When it comes to forfeiture, the advice around forfeiture really comes out where a client's seeking advice on continued non-payment of rent and they're looking for advice on their options, or if there's been breaches of covenant and they want to know how to force a tenant to take action, or sometimes the landlord simply wants their property back, the break date's passed, there's still a long time to run on the lease, and we consider it as part of a wider strategy and one of the options to terminate.
Yeah, so if it's that kind of strategic advice and there's a few different options on the table, what sort of factors would you be looking at indicating that forfeiture is not the right option for the landlord? There might be a different option, say surrender.
So I think for me, it's always really important to establish at the outset what your client wants. For example, is it remedying the breach? If it's non-payment of rent, do they want the arrears repaid? And do they want the tenant to continue in occupation, because they might actually be a good tenant and the landlord might not want the property back? Or is their ultimate goal to get possession? And I think it's really important to establish that, because if it is getting back the arrears, well, forfeiture might not be the best bet, because whilst you can get back possession, is that if the tenant doesn't seek relief from forfeiture, in which case they would have to pay back the rent to actually get back in the property. You might have to issue a debt claim. Any guarantor under the lease is released from their obligations. So I think you need to consider that. But then also where we turn to surrender, and we were discussing this, is surrender actually a better option? I get so many tenants coming to me going, well, we've reached out to our landlord to consider a surrender because we can't actually pay our rents going forward. We're in a bit of a tricky situation. We either want to agree a surrender or agree a repayment plan, and the landlord's just not engaging with us, which I find quite strange, because actually, if the tenant stops paying rent and the landlord seeks to forfeit, all the landlord can actually seek to recover is the rents accrued up until the date of forfeiture. Whereas otherwise, if you're considering a surrender, typically the starting point for a premium is repayment of rent up until the end of the lease, and you can tie up dilapidations. So you don't have to consider after you forfeit, now what claim can I bring if the tenant doesn't actually pay up?
Yeah, so that surrender option might work out better for the landlord, but not better for the tenant. So it depends who you're advising and what you're going to suggest.
Exactly. So what would be your advice as counsel on what we should be considering as practitioners from the outset?
So I think the first two things that need to be looked at are whether the right to forfeit has arisen. And that's going to be dependent on the terms of the lease. So the lease itself needs to contain, usually it will be phrased as a proviso for re-entry. It might use the word forfeiture as well. And then it will probably have a list of the situations in which the right to forfeit will arise. So the most common ones are non-payment of rent, but the right to forfeit itself might not arise until, say, 21 days after the rent has fallen due and not being paid. There might be a provision for any other breach of covenant or condition of the lease, and it might also include an act of insolvency, because landlords generally don't want insolvent tenants. So that's the first question: is there the right to forfeit? And then the second question: has that right to forfeit been waived by some act of the landlord treating the lease as still being in existence? Because that's a really important thing to understand about forfeiture, is you have to treat the lease as completely at an end. So there's always that risk of waiver, and that's particularly true in non-payment of rent cases. So what do you think about that? How would you be advising clients to avoid that risk?
Yeah, so as you said, the landlord needs to be really careful to ensure that they don't accidentally or inadvertently treat the lease as continuing. So for example, even chasing for rent, you suddenly waive the right and you might not have even thought about it. It might be a managing agent acting on your behalf who's chased. So you need to get to that point. And because with non-payment of rent, it's a once and for all breach. So once the right is waived, you have to wait until the next rent payment date before the right to forfeit arises again. So the first step I always do when considering forfeiture in terms of non-payment of rent, I'll always ask when the landlord last chased for rent. And if it was within the current rent period, then check when the next rent payment date is, because you might have a small period of time in which to take other action. It might be a long period of time, it might be a short period of time. But what you don't want to do is be caught in a situation where, say, you've got 2-3 weeks until the next rent payment date, and you've got that time to advise your client, and you might be able to chase on your client's behalf, because if they actually do want to recover the rent rather than forfeit, then there might be other options they can pursue. You might be able to send a letter to the tenant. You might be able to serve a stat demand. You might be able to reach out to the guarantor. But if they want to preserve the right to forfeit, then as soon as that next rent payment date hits, you need to tell them stop chasing, and you cannot accept rent as well. So tell them send the rent back, because even accepting the rent, something as small as accepting the rent, keeping it in your bank account, it can be seen to waive the right.
And I think that's a really good point that you just touched on. It might be a managing agent. You know, you kind of, as the landlord or as an advisor to the landlord, you need to make sure that everyone down the chain is aware of what they can and can't do, and keep that under wraps. So, two final steps to think about when it comes to forfeiture. The Section 146 notice. Are there any top tips that you could give to people drafting those notices?
Yeah, so I think you need to consider whether the breach is remedial or irremediable. And if it is remediable, you need to be giving a reasonable time to remedy the breach. And we all know that. But you really need to consider hard what is a reasonable time. And if there is any doubt, then use the wording insofar as the breach is capable of remedy. Now that's found in the PLC precedent, which a lot of people use. But if you're drafting off the cuff, or if you're getting someone else to draft that notice for you, make sure that wording is in there, because I think it's optional wording. So you want to make sure it is in there. And for example, where you're seeking to forfeit for breach of a repair covenant, you need to make sure that the wording of the referring to the Leasehold Property Repairs Act is in the notice. So if you've got a lease of at least 7 years and there's at least 3 years left to run, the notice needs to be referring to Section 1 of the Leasehold Property Repairs Act 1938, which means that a tenant is allowed to serve a counter notice and the landlord can't take steps to forfeit without consent of the court.
Those are good tips, thank you. So you've done all the steps that you need to do. You know, you've treated the lease as forfeit, you've served the notice if you need to. That final step of actually taking back possession, so that either through physical re-entry or through proceedings. But if we're looking at re-entry, what would your top tips be for that?
Yeah, so for example, where we're going by peaceful re-entry, my advice to clients is usually use a bailiff, just because otherwise tenants can get quite difficult if it is very contentious and a tenant really wants to remain in the property, or even if they don't, they might get a bit annoyed that a landlord's taken back possession. And the last thing you want is to say that you used force or you took any goods from the premises. So use a bailiff, do it outside of hours. I usually try and say to clients, where I'm instructing bailiffs on behalf of clients, take an inventory of the goods in the property, just so there can be no argument that any goods have been removed. And then immediately after possession after the landlord's taken back possession, I would usually advise on serving a torts notice, which deals with the goods and lets the tenant know when they can collect the goods, how long they'll be available for, and what will happen if they don't collect the goods.
Thank you, Farah, that's really helpful. So I think we're going to move on now to our second type or genre of possession claim, and these are the private rented claims.
Yeah, so as we know, there's a number of different types of tenancies when it comes to the private sector. And so what should advisors be looking out for?
So I think when you are at the very start of a private rented claim, the first step is to identify the type of tenancy. And before you can even get to that point, you need to be asking, is there a tenancy? Is there a written tenancy agreement? And what type of tenancy is it? So there's some of the older tenancies, if the tenant's been there for a long time, it could be a rent out protected tenancy, it could be a secure tenancy, and those are going to cause you some more problems. We're not going to look at those in detail today, because, as I said, they tend to be older tenancies, so they're not likely to be of as much relevance, but it is a whole subject on its own. So we're going to be talking about assured tenancies, and I think that these are the main kinds that you're going to come across. Might be assured or assured short hold tenancies, and most of the possession claims I deal with would be in that that field.
Yeah, I think they're the most common types I come across as well. So the two routes are Section 8 and Section 21 of the Housing Act 1988. So what are the similarities and what are the differences between the two routes?
So I would say the main similarity between those two routes is that you need to serve a notice in both cases. So a notice following the requirements in the Act and setting out the grounds if you're relying on Section 8. And after that notice, if the property is not vacated, then possession proceedings are going to be necessary. In terms of the main differences, Section 21 is more commonly called no-fault eviction. The government had proposed a ban on no-fault evictions, but that has been kicked down the road for now. So it's still a valid option for landlords, and it's still something that tenants need to be aware of. Section 8, on the other hand, you actually do need grounds. But let's look at Section 21 first, because I think if you've got both options, then you're probably going to choose Section 21. But there's lots of procedural hoops if you do go down this road. So what are the main hoops?
So I think we always consider this to be the most simple, and it is, but we do need to consider the hoops. So the first is, has the fixed term expired? And if it has, great, first step ticked. Have all the relevant documents been served? And there's been a lot of case law on this. The how to rent guide and gas safety certificate, which need to be served before the tenant moves into the property, and the EPC. And you made an interesting point to me on this one. And it wasn't a point I had actually thought about, because there seems to have been a lot of talk about the gas safety certificate and the EPC, especially in case law. How to rent guide, how many of you actually checked the date of the how to rent guide? You came across an interesting case.
Yes. So this was actually spotted by a judge. I heard about this. The how to rent guide that had been served on the tenant at the time the tenancy was created was not the most up-to-date edition at that time. And the judge considered that meant that it couldn't be relied on by the landlord, and that requirement under Section 21 wasn't met, so they had to go away and check whether they'd served the right edition. So that is, as we said, there are procedural hoops, and there's kind of layers within each of those hoops that you need to think.
So my mind was blown when you told me, because it's not something that I've checked in the past, because I asked, has the how to rent guide been served? But I think I can see how a client might come to me and go, well, you should have checked that. And it ends up coming back to you. And yeah, that, I think it's a really interesting point to note. Going on, has the tenant complained in the last 6 months, or has the council served any improvement notices? It could be seen as a retaliatory eviction. So you need to be careful about that. Just ask the client. And has the tenancy deposit been protected? So moving on from Section 21, which is straightforward enough, Section 8 can be a bit more complex, and the landlord needs grounds to take back possession. So can you give some examples of the types of grounds under Section 8?
Yes, so there are two categories of grounds, sometimes known as cases, under Section 8. They're contained in one of the schedules to the Housing Act. Some of the grounds are mandatory, so if the ground is made out, then the court must order possession, and some of them are discretionary, so the court retains discretion as to whether to order possession, even if the ground's made out. So one of the things that we talked about in our early discussions was non-payment of rent, because there is a rent ground in the mandatory section, and there's also a rent ground in the discretionary section. And so it might be worth considering whether actually, by waiting a little bit longer and finding that you can get yourself within the mandatory ground, it would be worth it, because then the court doesn't have that discretion to say no. A lot of the mandatory grounds require notice to have been given at the start of the lease. So this is one thing to look out for if you are trying to rely on one of the mandatory grounds. For example, the landlord wishes to occupy the property for themselves, and maybe they've gone abroad for a few years and they've rented out the property to someone, but now they're coming back and they want to move back in. If they've not served a notice at the time that they initially rented it out, then that's going to be a problem. So it's definitely something to look out for. There's also a few other kind of fault-based grounds, and they tend to be in the discretionary half. So damage to stuff within the property and that kind of thing. So yeah, there's quite a wide range, but it's important to read the text quite carefully, because if you're not within one of those grounds, then you can't rely on it.
Yeah.
And it's important to have put the ground in the Section 8 notice.
I think just off the back of that as well, where you're using more than one ground and there are different time periods, make sure you're using the longer time period.
Yeah.
Because otherwise you won't have the right to actually seek possession or make a claim for possession yet.
Yeah, that's a really good tip.
Mm.
So you've got your order, either by Section 21 or Section 8. That's not going to be the end of the road, as a lot of you will be aware. If the tenant doesn't leave of their own volition, and there might be reasons why they don't do that, it can have sort of implications for whether they can get council accommodation. Enforcement can be really difficult, mostly slow, especially in the county court. So what practical steps can practitioners take in the enforcement process to speed things along? Or...
Yeah, so if you do want to take back possession where a tenant hasn't left off the back of possession order, they haven't left by the date in the order, you need a writ or a warrant of the court to get a bailiff to go in and actually remove the tenant. As you said, county courts can be really slow, so there is the option to ask for a transfer to the High Court, but you need to submit a request to the county court first, seeking permission to transfer the enforcement aspect to the High Court. And all you have to do is cite Section 42 of the County Courts Act 1984 and give a valid reason. And that reason doesn't have to be anything too complex. It can literally be a long delay before the county court bailiff can attend. So I think that's a really useful tool. But saying that, I usually would get someone to try and call the county court's bailiff and the High Court to see what the time differences are going to be. Just because it's in the county court doesn't necessarily mean it's going to take longer. I do think sometimes it depends on the court and where you're at. Because if the times are going to be the same, you might spend that little bit of extra time trying to seek permission. So yeah, just definitely try and find out if you can beforehand. I know the courts are a bit of a nightmare to get through to, but it's worth checking.
Yeah, I would definitely echo that. I think that's a really good tip. I did a hearing where I was asking for a possession claim to be transferred up for enforcement to the High Court. And the only question that the judge had for me was, what's the time scale in the county court? What is that, why you're doing this? And she did say that if we put that information actually in the application notice, then they might have been able to deal with that application on the papers rather than having a hearing. So it can save you costs as well. So yeah, I think that's a good tip. And having covered enforcement in terms of private rent, I think we'll move on to mortgage possession proceedings.
Yeah. So at the outset, when does a mortgagee have the right to possession?
So I think this is an interesting one, and it can surprise people to know that the mortgagee is entitled to possession from the moment that ink dries on the mortgage deed. So that's always something to bear in mind. The right to possession might not be enforceable, or the deed might contain sort of provisions that say we'll only exercise our right to possession in circumstances, for example, if there's a default by the mortgagor. But the issue of right to possession, I would say, is probably likely to be less of a live issue in mortgage proceedings compared to the other possession proceedings that we've looked at.
So what provisions should the mortgagee be aware of in the deed?
So they need to be looking at what counts as a default, and also sometimes there's going to be cost provisions in the deed as well. So that's another thing to be aware of.
What about in terms of the law?
So more widely, if it's residential property, then they need to be aware of the mortgage pre-action protocol and follow that. And there's also a particular rule in Part 55 of the CPR, which applies to mortgage possession proceedings, and it provides that notice needs to be given to a particular set of people. So there are a few more hurdles for a mortgagee looking for possession to comply with procedurally.
So great. Okay, so once a mortgagee has figured out they do have the right, what, if anything, can the mortgagor do?
So this tends to be more of a difficult question. I think that a lot of mortgagors resist possession, but if they're in real trouble financially, if they're not going to be able to pay without selling the property, then the game is up in some ways. Often the only option realistically is to sell the property in order to pay off the debt. And the question therefore becomes who should have control of the sale, and how long can they delay possession for. So there are two sets of provisions. If it's a regulated agreement, then the Consumer Credit Act applies, and there's particular provisions in there. Otherwise, the provision is Section 36 of the Administration of Justice Act 1970, which applies to residential property. This has come up in every mortgage possession claim that I have done, and it gives the court a power to adjourn the hearing or postpone or suspend possession in circumstances where the mortgagor can show that they're likely to be able to pay the sums due within a reasonable period. There's quite a lot of case law on the meaning of that, but I would say it's more generous than you might think. So if the term hasn't yet expired, then a reasonable period will be the remainder of the term, whether that's a year or 20 years. And there's also another part of the Act which says that sums due should be interpreted as meaning sums due up to that date, even if there's an acceleration clause in the mortgage. So even if the mortgage says once you've defaulted, you owe everything, when we're looking at whether they can pay within a reasonable period, we're actually only looking at sums not discounting the acceleration clause. So that's a handy provision for mortgagors to rely on, but there are things that mortgagors need to be aware of. You need evidence, and you need good evidence that you are taking good proper steps to sell. If you want to sell, then you need to really realistically have some kind of memorandum, or at least offers on the table, but offers themselves might not be enough to delay possession. So you need good evidence that you are actually at kind of the business end of the sale process, not just that it's on Rightmove. That's probably not going to be enough. So yeah, that's definitely something to be aware of. And from a mortgagee point of view, if there's not that evidence, then you can hope that you'll be able to get control of the sale.
Great.
So taking possession as a mortgagee, and in fact, actually one of the themes of all the kind of possession proceedings we've looked at, taking possession comes with its own set of problems. What might a mortgagee or another party, perhaps a commercial landlord taking possession, need to be wary of when they're considering that?
So I think one of the first things they want to consider is, will taking back possession constitute a breach of the lease? Most leases contain a clause prohibiting the tenant from charging or subletting without the landlord's consent. They really want to know, has landlord's consent been obtained to charge the property? If that consent has been obtained, the landlord inherently consented to the mortgagor's right to seek possession of the property, so you're fine. is the property sublet? And if so, is the lease binding on the mortgagee? If not, fine, go ahead, take possession. Otherwise, will the mortgagee need to give notice to the subtenant? So I think you need to consider those points at the outset. I think the mortgagee will also want to consider what liabilities it's taking on once it's taken possession. So there's liability to account for willful default. So once the mortgagee becomes mortgagee in possession, they act as owner of the property. So they effectively become the manager of the property, and they owe duties to the mortgagor, including collection of rents and profits. And that's not just receiving the rents and profits as they come in, because what if a tenant stops paying? So the mortgagee needs to employ all the usual means of recovering arrears, including taking proceedings if that's what's considered necessary. If they decide not to sell, they might be obliged to rent the property and must exercise reasonable care and skill in doing so. The way they're marketing the property, who they let the property to. They also become liable for deliberate and negligent damage. So they've got an equitable duty to give the property back in the same state or in which it was taken possession of upon redemption. And there's a liability to repair and maintain the property, although the cost of repair can be charged to the mortgagor's account. So the mortgagee in possession might inadvertently expose itself to third-party liabilities as owner. For example, liability and negligence or nuisance to third parties, neighbours, liability for rates to the council, and liability under the Occupiers Liability Act, just to mention some of the liability they're taking on. And there's actually more than that, but those are the main ones. I'd be thinking, if you're acting for a mortgagee, you're really considering, well, is this worthwhile? Even if you're acting for a mortgagor and you're trying to negotiate, you maybe want to just make the mortgagee consider what they're doing.
Yeah, I was going to make that point actually, and I think a lot of mortgagors could benefit from kind of drawing these drawbacks to the mortgagee's attention. There is a point when they become so kind of focused on possession that perhaps they're not going to take these things into account. But I think there are a lot of problems in taking possession that should put mortgagees off. And as I said, if you as a mortgagor can take control of the sale, that's probably going to be easier than for the mortgagee than for them doing it themselves. And yeah, perhaps it would reassure a mortgagor as well to know that all of those duties do apply to mortgagees in possession. So just sorry, just generally before we wrap things up, there's a couple of points that I just wanted to raise. It came up in our discussions. There are breathing space moratoriums that probably most practitioners will have come across. Those do have an effect on possession proceedings and enforcement. There's a really good guide actually, and I wanted to draw this to your attention anyway. Shelter do quite a lot of quite helpful notes on possession related issues, and often a good place to start because they have footnotes to all the relevant statutes. So if you want an overview of the breathing space provisions, then that's quite a nice place to go to. If the moratorium is in place, then proceedings shouldn't be started. It kind of stops you from taking any steps in relation to enforcement of a debt that's covered. One thing to be aware of is it doesn't necessarily stop you from taking steps in relation to other grounds of possession. So Section 21 notice still an available option, even if there's a moratorium in place. I don't know if you had any kind of insights on breathing space that you wanted to share.
Yeah, no, I just think it's being alive to them. I think especially if you're acting for tenant, do utilise it. If you're acting for landlord, maybe use that time to try and tell your landlord to speak to the tenant. Sometimes it is that simple, and people get so caught up in what's happening and going, yeah, we're taking legal advice, we're going to get back possession. they often don't realise that there's a whole lot more to it. There's costs associated with it. It's stressful. And sometimes they think, okay, it's these immediate costs. I'm instructing counsel or solicitors to take these steps. I'll get back possession. But as we spoke about, when it comes to forfeiture, when it comes to the private rented sector, have you thought about, well, actually, am I getting back the arrears, or would it be better to just reach a deal? Would it be better to agree a surrender? Would it be better to speak to my tenant and find out exactly where they're at? Can a deal be reached? And I think if that option's exhausted, then you take the next step. And it's the same with mortgagees and mortgagors. Sometimes a simple conversation can be really effective. Yeah, I don't think there's enough that can be said for it.
I completely agree. I think the final thing then, just to mention, if you are at the point where, you know, negotiations have not succeeded, and possession proceedings are going to need to be brought in court, then CPR 55 it is going to be your best friend. I think it's one of the most kind of accessible parts of the CPR in many ways. It is quite clear, quite prescriptive on the steps that need to be taken to bring a claim for possession, and that would always be my starting point. So yeah,
just as a final point on that as well, I think where there is any doubt about any provisions, whether it be a forfeiture provision in a lease or taking back possession when acting on behalf of a mortgagee or a mortgagor, or even in private rented, if there's any doubt as to what's in the agreement, seek counsel's advice from the outset. Your client is not going to thank you if you take a punt or make a guess and then it goes horribly wrong and then you're having to backtrack. I actually quite like using counsel for drafting the claim documents, especially if you think it's going to end up in court, just so there's that, it just flows better. Because counsel will have drafted the proceedings exactly how they want to present the case, and that's not to say you don't have that input, but if it's ending up at court, ultimately they're the ones who are going to have to be presenting it to a judge.
Yeah, I think that's a good point as well. Okay, I think that brings us to the end. Hopefully it's been really helpful. Again, thank you all so much for joining us. In terms of questions, given that we kind of can't really see you, we thought it would be easier to take questions by email. So if you do have any questions for us, then please do get in touch by email. My email is just aturner@radcliffechambers.com.
And mine is farah.bandali@shma.co.uk.
So yeah, we're definitely really open to any comments, thoughts, questions by email. But that brings us to a close. And thank you again, and thank you very much to Farah, who has made this very worthwhile. Thank you.